Call to order the meeting of the Delray Beach Board of Adjustment for September 7th, 2023. Please call the roll.
Brenda Cullen.
Here.
Jesse Slosser.
Here.
Vlad Dumitrescu.
Here.
Alec Hayes.
Here.
Mike Miles.
Here.
Robert Cohen.
Here. Are there any changes to the agenda? Would like a motion to approve the agenda?
I'll make a motion to approve the agenda.
Second.
Brenda Cullen.
Here.
Jesse
Yes.
Slosser.
Yes.
Vlad Dumitrescu.
Yes.
Alec Hayes.
Yes.
Mike Miles. Robert Cohen.
Yes. Are there any comments or changes to the draft minutes for the October 3rd, 2023 meeting?
Just to clarify, this is August 3rd.
Sorry.
No.
I was reading it and I read it wrong. August 3rd, yes. No changes or comments? Would we make a motion to approve the meetings for the August 3rd meeting?
I'll make a motion to approve it for August 3rd.
Brenda Cullen.
Yes?
Jesse Slosser.
Yes.
Vlad Dumitrescu.
Yes.
Alec Hayes.
Yes.
Mike Miles. Robert Cohen.
Yes. For the swearing in of those in the public that are going to speak.
Please raise your right hand. By the authority vested in me, the notary of the state of Florida, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
This hearing shall be conducted in accordance with the City of Delray Beach quasi-judicial rules. The applicant and the city shall be permitted to present their case. The public shall be allowed to speak for 3 minutes each, or a maximum of 6 minutes if the person represents an organization or group of people who are present but agree not to speak. The city commission, board members, staff, and the applicant may be allowed to cross-examine a witness. The city or the applicant will be allowed to offer rebuttal testimony. The decision to approve or deny an application or appeal may not legally be made upon personal views as to whether a project is a good project or not, nor may a decision be based on the numbers of citizens who support or oppose a particular project. The law requires that all decisions must be made on the basis of whether the project meets the requirements of law, the comprehensive plan, and the land development regulations. Are there any ex parte communications?
So, Chair, we actually have public comments for non-agenda items first, if we can call that.
Oh, yeah, sorry. Are there any comments from the public relative to an item that is not on the agenda? I see none offered.
So then we'd be ready to call 7A, which is file number 2023-228.
All right.
And now we could ask
Now
for
we
ex
ask
parte.
for, I want to do the ex parte case by case.
Yes.
Does anyone on the board have any ex parte communications relative to case 2023-228-942 Evergreen Drive?
No.
No. All right. The applicant is ready.
I am, Mr. Chair. I'm waiting for the clerk to get us ready.
Chair, do we need to enter the file into the record?
I think Anthea's about to do that.
Good evening, Anthea Geniotis, Development Services Director, and I'd like to enter file 2023-228 into the record. The subject request is a variance regarding a boat lift from section 7.911.
Sorry, Mr. Chair, let me get there 1 second. Control L. There we go. Thank you so much. Good evening. My name is Neil Schiller. I'm with Government Law Group at 137 Northwest 1st Avenue. I'm here tonight representing the owners of 942 Evergreen Drive, Mr. Troy Gagliardi and Ms. Desiree Cook. We're here tonight seeking a variance for a boat lift and dock that was installed that creates a violation of the code. It is an unusual situation. This applicant relied on the city's issuance of the permit to its detriment. They constructed a dock and a boat lift, based on approved plans by the city. The neighbor who's here tonight, I'm sure you'll hear from, filed code enforcement complaints about the boat lift, and the city cited the applicant. And ta-da, we're here in front of you tonight. I want to go through this, but this is the property. You can see highlighted in yellow, and I'll go back to this aerial in a few minutes. But this all began in March 24th of 2022 when the applicant submitted its permits for dock improvements and a boat lift. You can see up on the screen the exhibit that shows the existing site plan and the proposed site plan. On that site plan, it shows clearly that a boat with a boat lift extending into the 10 feet setback, which clearly it shouldn't be. Again, it shows a proposed 27,000-pound boat lift with a proposed wood dock. On June 14th, the applicant submitted a revised application because the first time they came in, they sought a dock of larger than 50 feet, which created a little more criteria that they had to meet. So they, instead of meeting that criteria, they chose to revise the dock to a 50-foot dock instead of a larger than 50-foot dock. On August 1st, 2022, city engineering signed off for code compliance. On the 2nd, development services signed off for code compliance. On the 4th, the building department signed off on code compliance. You can see that here. This is a copy of the site copy. This is the plan that was on site, and it shows the 3 sign-offs and the permit number. And the data was received, and it says new plans reduced back to 50 feet. On January 31st, 2023, we received our code enforcement citation for 2 things. One, that the boat lift in the raised position must be within 20 feet of the seawall. We contend very much so that it is within the 20 feet distance. Shows it clearly on the plan. Secondly, the boat in raised position shall not be within 10 feet of the adjacent property line. Ladies and gentlemen, it's within 10 feet of the adjacent property line, and that's why we're here tonight. On plan review, so when you go through a process of building permits, you go through plan reviews, staff goes through the application to make sure it's consistent with the code. So we have 2 sets of plan reviews up here. One on August 2nd, 2023, where it shows that planning and zoning approved the plan, and then on January 3rd, 2023, after the code enforcement complaint was lodged, the plan review was updated to show it was disapproved. But ladies and gentlemen, the dock was already built. The construction and the improvements were already done. Here are inspections showing September 1st, the week of November 14th, November 23rd, all the way to November 30th. So there were a number of different inspections that were made to ensure that the dock and the boat lift were constructed in accordance to the approved plans, which they were. Now we get to the variance criteria. So your code has variance criteria. I think there are 4 or 5 of them. I'm going to get to them. The first and most important one is, does a special condition exist? And unfortunately, it does. It does exist here. These plans were approved. We built to the plan. It was inspected and signed off. And then we got cited for code enforcement. Without the city approving the permit, the construction wouldn't have started. We wouldn't have built the dock and the boat lift and have this problem. Further, my client had several conversations with staff via phone and in person, and again, they're not trying to get out of a responsibility or not comply with the code. They had a permit. They built to the permit, and it's unfortunate that that permit violated the code. B, literal interpretation of the regulations would deprive applicants of rights commonly enjoyed by other properties subject to the same zoning. It has nothing to do with zoning. If somebody else in a same zoning district was seeking to build a dock, they would have gone through the same process. Conceivably, their dock would have been code compliant. Ours wasn't. And again, we built according to the approved plan. Third, special conditions or circumstances have not resulted from the actions of the applicant. Again, we didn't approve the plan. We submitted the plan was approved, and then we built to the plan, and now we're violating the code. It's unfortunate that this happened. There may be a question about, well, you were putting in a boat dock, you should have gotten an electrical inspection. Frankly, our dock already had electrical on it. We weren't touching the electrical, thus an electrical inspection wasn't needed based on the conversation my client had with the building official. D, granting the variance will not confer onto the applicant any special privilege. Well, there won't be a special privilege. My client drove up and down the Lisbon Canal and found at least 3 instances of boats in their lifts violating the side setback. In fact, if you go to back to the aerial, you can see very clearly this boat violating the side setback. This one violating the side setback. There are numerous instances of this, so I don't know that that confers a uniquely special privilege. Frankly, this has been a tremendous inconvenience for my client, as you can imagine. E, the reasons set forth in the variance petition justify granting the variance. The variance sought allows the boat lift and dock to remain as is. This is the minimum allowable use to make reasonable use of the structure. This is the minimum amount we're seeking so that we don't have to move the boat lift or move the dock and spend the money to do that. F, granting of the variance will be in harmony with the general purpose and intent of the existing regulations. Well, if we're being subject to this 10-foot setback, then everybody else should be subject to that 10-foot setback. And I think I've already shown 5 different examples of that 10-foot setback not being respected by other people along the canal. Additionally, let's talk about views and view corridors, because there are some rights guaranteed under Florida law that allows riparian owners to have ingress and egress and views of the channel. However, that view of the channel isn't a view from your kitchen window, your living room window, your bedroom window. It's a view to ensure that the channel is navigable. It's a public safety issue. It's not a view, just a plain view issue. So I would take a little bit of umbrage with the regional visual access to public waterways when Florida law does have limited reasonable access, but that view is not just a view out of your house, it's a view from your property also. I think that should be considered, and I don't know that any evidence that the boat in the fully lifted position has created navigable issues. And I know that hasn't been issued or none of that evidence has been submitted yet. But according to my client, the boat has never been in the fully lifted position. It's never been fully lifted up because they recognize that it may impact the views to their neighbor. And then we have equitable estoppel, and this is a legal theory. It's a defensive doctrine preventing one party from taking unfair advantage of another when through false language or conduct that person is to be estopped is induce another person to act in a certain way in which resulted in the other person being injured in some way. That's just the definition of equitable estoppel. So we feel, again, the city approved the permit, the zoning staff approved the permit, the property owner constructed to the permit, and then the property owner got cited for the permit that they constructed to. Again, we feel that an issue here is equitable estoppel, and we would, put that on the record. In conclusion, we meet all the criteria for the variance. There's a uniquely special condition that exists here. There's no harm to public health that's been alleged or proven. It's been approved by the city. This is the site copy. And I'll just say this: I know you've received letters on the server about how could we do this? How could my client do this? They built without a permit. That is patently false, and I want to make that extremely clear to everybody here. The applicants here built to a permit that was approved by the city. They didn't build beyond the permit. They didn't build under the permit. They built to the permit. It was inspected a multitude of times. And so, if nothing else, I want to make it clear and on the record, a permit was issued, they built to it, and then were cited. And I'll get off my soapbox and let the city proceed with its case. Thank you.
Okay. My name is Anthea Geniotis. I'm the Development Services Director. And just to be clear, that means that I am over both the Building Department and the Planning and Zoning Division. So, the buck stops with me on these things, and I want to make that clear. So what's before you is a variance in this board. As you know, this is mostly what you hear. And a variance is not related to process. It's related to specific findings peculiar to the land, not to the process that got you to where you are now. So let's just go through. This is an existing single-family residence. It's located in the Tropic Isles neighborhood. The zoning is R1 AAB, and the use is single-family. The zoning matters because that tells us the position that different pieces of things that are regulated by Chapter 7, docks, finger piers, boat lifts, etc., where they can be located. So according to LDR Section 7911A, we are allowed to have boat lifts that are located so that the vessel in the raised position, right, doesn't extend any closer than the side setback or 10 feet, whichever is greater. In this case, the variance request is to allow a boat lift to be located so that the vessel in the raised position extends closer than 10 feet to the property line. That's the side setback in this zoning district. So what's interesting is we're talking about the boat that you choose to put on the boat lift, which is part of how this gets a little dicey over time with what's out there. The second thing is that LDR Section 911B allows a boat lift provided it doesn't project more than 20 feet into the waterway from the seawall. And so that is the condition that this boat lift is theoretically built under. So again, compliance with these rules depends upon the vessel that you choose to purchase, that the city is not with you when you buy it, things like that. And that the boat, so when Mr. Schiller is showing you an aerial, you can't tell whether the boat is moored next to a dock or whether it's raised up out of the water. So, all of these things are factors in terms of the visual impact that the neighbors have. So for example, just while we're talking about the way the rules work, if you have a boat lift that is set back 15 feet from a side property line, it might be in compliance for a vessel of one size and maybe completely out of compliance for a larger boat. And that's where it gets tricky over time. Properties exchange hands, people buy different size boats, etc. Just to give you a general thing. Now in this case, on March 24th in 2022, a building permit application number 22-203195 was filed. The description of the improvements were remove and install new dock. It does not say remove and install new dock and boat lift. And I will show you everything that we had, and I'm not, suggesting that the city's team, couldn't have done a better job, but we have a machine and we route things based on the information that you give us. And the more clear the information you give us is, the more likely it will get routed in the right direction. At that time, the drawings indicated that a dock was going to be demolished and the same dock was going to be rebuilt in, quote, approximately the existing location, which put it 19 feet from the western property line and over 21 feet from the eastern property line. Plenty of room on either side. Didn't matter where the boat lift went, unless you got a 50-foot wide, again, the vessel size and the upright position. When a dock exceeds 50 feet in length, there's another set of requirements that it's tripped related to providing power outlets, a sewage pump with the ladders that have to be placed for safety. So there was a comment that the dock appeared to exceed 50 feet in length, and therefore they needed to provide the electrical contractor's information and these other standards. So those comments were made to the applicant for their new dock on April 26, 2022. We also told them that we needed to get approval from FDEP that it was okay that you were going to build this. So on June 14th, revised plans were submitted, which clarified that the dock is exactly 50 feet long and does not require, therefore, to have electrical outlets, a sewage pump out, and those ladders. So section 796 is no longer applicable. The updated drawings repositioned the dock. The dock is now 10 feet from the western property line, which is the minimum setback required, and 30 feet from the eastern property line, because I'm sure that gives this applicant a much better view from their pool. The position of the dock is in compliance. That is not the problem. The dock that was removed and the dock that was built are fine. It's the boat lift, which is illustrated on the plans and details that were submitted as part of the FDEP review, that is positioned in such a way that the boat will overhang into the side setback. So, how did we get here? Your description did not say remove a dock, build a dock, and install a new boat lift. That doesn't help it go in the right direction. But to be fair, the details that were submitted to FDEP included details for a boat lift. The dock and the boat lift are not exactly where we told FDEP we were going to put them, but we figured the dock was smaller, we wouldn't run them back through that requirement. So the dock was replaced. There is no walk around, which I'll show you an image of, on the boat lift that was submitted to FDEP that is evident on the boat lift today. And again, the city determined, well, the dock is smaller and it's, we don't need to run them back. So on August 5th, the permit was issued to remove and install the new dock. I think I went through this. So inspections of the dock were conducted. Final inspections were completed on December 1st. I think it's important for you to understand that we see thousands and thousands of permits, and people do build out their property in phases. I can afford the dock this year, but I can't afford the boat lift. I can afford, I can't do the pool, but I'm going to do the house. I can't do the guest cottage, but, so it's not that out of the ordinary to suggest that only part of what was approved by DEP was coming in. Ultimately, we did receive a complaint from the neighbors in late 2022 that the vessel in the upright position was too close to their property. So here's the walk around, to, I guess, clean things. So code violation number 23-0001615 was issued, citing the LDR provision for boat lifts vessels and directing the property owner to submit a permit for the boat lift or to seek a variance for the encroachment that the position that the boat lift results in, right? The reason that this has to happen, and for anyone watching from home, this is why it's really important that we're exchanging very clear comments with each other. Because at the end of the day, the city's code is very clear with the conditions of any building permit we issue, right? Is that a permit issued shall not be construed as an authority to violate the code, and it doesn't prevent the building official from requiring a correction. So, in May of 2023, the variance was submitted. As you know, those of you who are experienced, one of the criteria is that you're supposed to be considering the minimum variance amount required to be reasonable. So that requires dimensions, so we know exactly what's going on. And again, because some of this is related to the vessel that you've chosen to put in the upright position, we needed to have somebody provide these dimensions. So there were requests for more information, the location of the lift, the size of the lift, including the walk around, the setbacks of the lift, and how far the lift projected into the water. So that was May. In August, we finally received a boundary survey, but you'll note in the backup that it's not dimensioned in terms of how far out the boat lift goes, or the width of it, or the setback of it, or anything else. So typically, we would ask for more sufficiency before we bring it to this board. But this has been dragging on a long time, and while I appreciate that the applicant is frustrated and that the city is frustrated, the neighbors are also frustrated, and they have a right to due process. So that's part of why we're bringing this here to you. The request is to encroach by about 6 feet. So I guess that's a setback of about 4 feet. And when we scale the survey staff, because they're provided to scale, it appears that the projection of the lift extends beyond the 20 feet that the details provided to FDEP showed. So rather than submit additional sufficiency comments, we don't want to have further delay in resolving the situation. So the item before you to consider as the Board of Adjustment is a variance to these sections in Section 791. The overall intent of this section is to permit the construction in and upon certain waterways of docks, dolphins, finger piers that do not cause hazardous interference with navigation. So that 20-foot projection out has to do with how far out you're putting your stuff. People across the canal are putting theirs to make sure we have a navigable waterway. Then there's other things that are you endangering life, property, or denying the public reasonable visual access to public waterways. These regulations apply to single-family districts like this. So a variance, which is before you today, is considered a relaxation of the terms of these LDRs, right? And the reason is that the variance will not be contrary to public interest. There is a condition peculiar to the property, not to your permit application, to the property, and that it's not the result of the action of the landowners. And as you know, the standards that we go through for a variance in order for the board order to pass, every condition has to be met. So the first condition is there a special circumstances that exist that is peculiar to the land, structure, or building involved, which are generally not applicable to other land, structures, or properties. And it specifically says economic hardship cannot be a basis for granting the variance. If it's in the wrong place, it has to move. And we have to figure out how to move it, but just because it's expensive to move it doesn't mean you don't have to move it, okay? The second criteria is that a literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning. This lot is, I believe, 90 feet wide. There is more than ample room to provide a generous dock and a position of boat lift to hold a boat without infringing on the side setback that are entitled to provide some relief between neighbors, including for, I don't know, getting the boats on and off. If everybody's got one, That said, I appreciate that the canals are quite crowded, but it doesn't mean, that we keep making a mistake that is going to affect how, your neighbors can position and navigate their boats. So the granting of the variance cannot be a special privilege that would be not denied to other land structures and buildings in the same zoning. Adhering to the minimum setback is, if we're going to say that no one has a setback, we're going to have a problem moving forward with how any boat lift docks and other navigable waters result in the end. And that the reasons set forward in the petition justify granting the variance, and that the variance, at the very least, this is the issue at hand, is the minimum variance necessary to make reasonable use of the land. A variance is not necessary to position these elements properly in front of this property. And even if you wanted to grant a variance, the burden is on the applicant to provide the dimension needed in order to receive this, approval, and we still don't know the exact dimensions. And some of that is inherently difficult because we don't know how big the vessels people buy are. But this is there, so it shouldn't be that hard to provide these dimensions and measurements for your consideration. So, and then finally, E, that the granting of the variance will be in harmony with the general purpose and intent of the existing regulations and will not be injurious to the neighborhood or otherwise detrimental to the public welfare. This position and the size of the boat on the boat lift are directly impacting the neighbors, and they're here, so I'll let them make that comment. And I go back to this issue. Whether or not, you like it, the design professionals that sign and seal and submit their drawings, whether they're for buildings or boat lifts, are responsible for making sure that they meet all of the code. Yes, we should check it. Yes, we should say, it's not just the structure of the dock. Where is your boat lift ultimately going to be? Because if you put a boat that's bigger than this, you're going to be in trouble. So we're talking about ways to try to stamp a note onto future docks that says, beware your vessel size matters, and you have to be careful that you're no closer than this. So those are the sort of internal adjustments we're considering making, but ultimately an error in the process does not mean that the neighbors have to live with a dock or a boat lift or a vessel that is erroneously positioned. If it's going to impact their quality of life, and if there is nothing specific to the property that limits the proper position, it simply cannot be approved. So the actions that you're considering right now are to reduce the side setback to 4 feet. I guess with the technical note that we would conform it later, and that we would allow the boat lift to project beyond the 20 feet if in fact it's positioned currently beyond the 20 feet. The details show 20. The survey, which are done to scale, appears to be at about 25 based on our scaling of the drawing. And so that concludes sort of my explanation of how we got here and where I think we need to go to correct it. Thank you.
Let me see where we're at here. Okay. Any rebuttal on the part of the applicant?
Chair, we'll do public comment first.
Okay, all right. That should be first? All right. Let's do this. Too many schedules. Okay. Do we know how many people we have that are going to speak? And is anyone speaking for a group rather than yourself? All right, if you're speaking for yourself, you have a speech where you can speak for 3 minutes. And then
First of all, good afternoon. I'd like to introduce myself. I'm Wayne Waller.
Sorry, one thing real quick. Diane, can you just make sure that the applicant receives a copy of whatever's being provided to the board? Thank you.
Sure.
My apologies.
No problem. I live at 936 Evergreen Drive, the property directly adjacent to the applicant, to the west. My wife and I have lived there for 25 years. We love Delray Beach, and of course we love Tropic Isle Subdivision. And we want to thank you for the ability to come before you and speak this afternoon. I want to give you a little history and background on this situation. It's been going on for some time. Since November of last year, which is a little over 10 months now. We took a look outside of our backyard and saw that the applicant was building a boat lift and seemed to be a little bit large and coming across our property line. We filed a formal complaint with the city at that time, and lo and behold, we had 5 individual city employees appear at our property at different times, and they all stated we had a justifiable complaint, that it was encroaching upon our easement, and again, that they would address it. Okay. I want to make pointedly and vehemently clear that my wife and I are absolutely opposed to this variance in all circumstances. And why? Number one, it obstructs the view from the canal, not only from inside our house and not only from our kitchen, but from our pool and our yard and where we were able to see up the canal previously. Okay. We've owned a boat in the past, a 32-foot cruiser, and we've sold it, and we're in the market to look for another boat. With the extension of this into the canal the way it is and the closeness that it has, it's going to inflict a little bit of hurt on us getting in and out and possibly the danger of colliding. Shouldn't happen. But more importantly, and most importantly, what we're concerned about is the value of our property and our house. If it was your house and you were selling it and someone walked in the front door and looked out and saw this boat sticking up in the air, they probably wouldn't pay you your list price or negotiate for a lower price on that house. This has been a blatant disregard for the codes and ordinance of Delray Beach and shouldn't be allowed. There's no reason or justification to install this boat lift where it was installed. There's a 90-foot seawall. There's a 50-foot dock. They had more than enough room to install a boat lift without infringing on our easement. They have 30 feet to the other side of it. There's no reason why it shouldn't be moved down. We would like to see, there's no circumstances where we would see that would require a variance. We'd like to set it very, it was going to set a very bad precedent in the neighborhood, not only in Tropic Isle, but in the city of Delray Beach.
15 seconds, please.
Okay. Elevator needs to be moved or removed. Bottom line, end of statement. We've actually sent out letters to the people in the community, and we've had 25 people respond that also oppose the variance. And we've submitted those to the board. And with that, I thank you very much.
My name is Fred Fetzer. I live at 932 Evergreen Drive in Tropic Isle. I've been a resident of Delray Beach for 41 years and been in Tropic Isle for 41 years, so it's pretty obvious I too appreciate our city and love our city and our community. When Tropic Isle was first developed in the 1970s, there was not a homeowners association that we became part of. So we've been totally reliant on the city's city enforcement, code enforcement. And that's not been a bad problem for us because the city has been responsive to us. In all those years I've been there, I've had several occasions that I've gone to code enforcement and asked for assistance, and the city's always really absolutely tried their best to work with us and consider the complaint that we've had and try to help us as neighbors. The code enforcement violation that you're addressing here tonight, it's an important issue for our waterfront community. And I agree, if it's granted, it's going to set a very bad precedent for our other people in our waterfront community. I'm here tonight strictly to ask for you to enforce the city codes as it relates to encroachment on my neighbor's property and the eyesore that this applicant has deliberately created. Thank you.
Hi, good evening. My name is Lori Levinson. I live at 1035 South Federal Highway, apartment 213 in Delray. I formerly lived across the street from the applicant. This is really a very simple case, one that should not require much effort on your part. First, the applicant is required to meet all 4 of the requirements for a variance. As outlined in your staff's report, he has met none of them. Second, His affirmative response is based on the argument that since the city issued a building permit, you must approve the variance. This is a wrong statement, as I'm sure you all know. In fact, the code specifically states on page 6 of your staff report, the permit issued shall be construed to be a license to proceed with the work and shall not be construed as an authority to violate, cancel, alter, or set aside any of the provisions of this code, nor shall such issuance of a permit prevent the building official from thereafter requiring a correction of errors in plans or in construction or violations of the code. Your staff also reports that the only reason Mr. Gagliardi wants this variant is for financial reasons. He does not want to pay to move the lift. Mr. Gagliardi has 90 feet of frontage on the waterway. He should have known from the beginning to maintain the 10-foot setback. And at the very least, his contractor should have advised him of that fact. I urge you to deny the applicant's request for a variant.
Thank you. Is there anyone else in the audience that wants to speak on this case? Is there any rebuttal or cross-examination from the applicant or the city? The applicant first.
Yes, Mr. Chair. I just have some brief rebuttal. Number one, precedent. As this board well knows, that every case variance is not precedent setting because every variance has to have a unique set of special circumstances. I want to put that in the record. Again, the last speaker said something that made me think a little bit. A building permit is the city's license to proceed with the work. So that's what we did. we proceeded with the work to our detriment. I can understand that the neighbors are upset. Their value of their home with the lot prices going down and not getting list price, I don't think is a consideration for you. At the end of the day, the city, there may be culpability on both sides, there may be, but at the end of the day, we built to the plan. All we're seeking to do is to have approved what we thought was approved when the plan was approved. There's no testimony. There was no testimony of economic hardship. There was no, really what their testimony is of fairness. This is a fairness issue. It is very simple, as Ms. Levinson said. This is a fairness issue. We built to the plan, and now we're getting cited for it. So there's that. Thank you.
Thank you. From the city?
So the LDRs are not fairness just for one property owner. It's fairness for everyone. That's why setbacks matter. I'm happy to tell you the dock is in the right place. The permit for the removal and installation of the dock is in the right place, which didn't require electrical review or inspection because it was a dock that didn't have any electrical outlets on it. I mean, I don't think they're hand cranking the boat lift. So ultimately, issues like this happen when there's a disconnect in the information. And I think it is up to the city and the applicant to resolve it. It is not something that the neighbors have to live with here forever just because there was a mistake in the process. If it's not a financial issue, move the boat lift over. It's a 90-foot wide piece of property with a 50-foot long dock.
Thank you. Are there any comments from anyone on the board or questions?
I have a question. So if the lift was built correctly, is that correct or not? The issue is that the boat is overhanging and is infringing into that 10-foot setback. Otherwise, if let's, for example, there's no boat, there is no violation. Am I correct in understanding?
That is correct. However, to be fair to the applicant, the proposed boat lift, well, this is the DEP one. There was room on the DEP one. Hang on, let me back up. If this is the arm of the boat lift, unless, and I'm no marine expert, but
No, not a boat.
there's no way to put any boat on this without overhearing into the 10-foot setback. And so that said, the position of boat lifts, though, the structure's fine. The structure's not too close. The structure could be moved over 10 feet, and if you put a vessel that is too large, then the vessel could still be at issue. To be fair to the applicant, there is no vessel that is going onto this boat lift with the one arm right at the 10-foot. That isn't going to be a code violation, so that the lift needs to move over.
I mean, obviously now you could probably fix this and add some sort of conditions of the overhang, like balconies and things like that, and
Right.
and for next time. But yeah, I just want to understand exactly
Yeah.
the situation.
Is the walk around considered part of the boat lift itself, definitions wise?
You want to try?
Yeah, related to the walk around. So I spoke to my client about that. That was truthfully, and I'm putting this on the record, it was added on after the fact. He's gonna remove the walk around, so it will be code compliant with FDEP.
So what I'm struggling with is on the east side of everything, so it seems like the other boat east of that property is also in non-compliance. So dates aside, if this happened over the last year or so, would this, if that property was built prior to this code, would that be an existing non-conformity that would be okay? Or if they get cited in the same boat? No.
That was well done.
That was good.
Okay, so, when these things happen and we start, all right, I'm looking at Jennifer, because Jennifer Buse ends up doing a lot of research for us on things that are odd. So a lot of docks and boat lifts happen in the city without permits at all because we don't see them. So, unless we happen to notice, Google Earth has, opened our eyes over the years. But I don't think that just because your neighbor bought a boat that's too big that encroaches means that you should have the right to have a boat lift that is positioned in a way that any vessel you buy will encroach. I'm looking to William now.
No, well, and I think Anthea is actually commenting on something that I made a note about. We saw those other pictures that are maybe examples. Without surveys and measurements, you don't know for certain. But you also didn't hear any evidence whether those properties were built under a different code, whether those properties received a variance or not. So it's not necessarily that all these other people aren't being enforced against, which is also irrelevant underneath the 6 elements, but that there's no evidence to suggest that they're not compliant because we just don't have enough facts to really determine that.
So my question
Yeah.
is, if the code was not there and this was built and tomorrow it got adopted as it states today, is that an issue?
Yeah, no, so they'd be a legal nonconformity. So we have certain thresholds that once they redevelop the property to a certain amount, that they're required to become completely code compliant. But if in theory the boat was within the 10-foot setback at a time when the rule didn't exist, then potentially it would be a legal nonconformity.
I see what you're asking, that if the setback was, say, 5 feet then, and now the setback is the minimum zoning, do they have to change it? They wouldn't have to change it unless, as Mr. Bennett stated, they were coming in to do a significant overhaul. But I mean, to be fair to everyone involved in this, the tricky part with all of these things is it depends a lot on the vessel size and people buy bigger boats but the rules are there for a number of reasons. Some are visual access, but it's also navigability. Some of the pictures Mr. Waller is submitting, they're having to use each other's frontages to navigate. And you got to have a little room between these things for that to happen. So, you know, and ultimately the findings are what you have to make the decision based on. And look, I'm sure everyone in Tropic Isles is doing, you know, doesn't have a financial hardship, but nonetheless, otherwise you would move it because, I understand why they don't want to, but it needs to get moved, and that can be resolved through different processes. The question for you is whether the standards under 247A that you have to use to grant a variance have been met. And, you know, is there something special? And I would just submit to you that, you know, a permit process is not special. It doesn't absolve you of the setbacks to the neighbors because you slipped one past the goalie. And it's just not how LDRs work, and it's not how the building code works, which is why the code reminds everyone that you are ultimately responsible for ensuring that you're, you know, in compliance. So is a literal interpretation going to deprive the applicant of rights? There is still ample room for a dock and for a boat lift. So I'm sorry, go ahead.
No, I was waiting. I have more questions than anything.
Okay.
After reviewing all these documents, there are a number of funny inconsistencies that exist. For example, there are two versions of the same drawing that shows the existing dock and the proposed dock. One was, I have to look at the exact title, the copy attached to the permit application.
Mm-hmm.
And that shows, and then the second one is the one that was produced by I call it the DEP. There's the DEP version of the same drawing. The existing drawing on both of those sheets is the same. The proposed design is completely different.
Yes.
On those two drawings. The proposed design shows that the dock is much further east, and the space between that and the property line is much greater. Then the third thing is there's a survey. The date on the survey is June 1st, 2023. Very brand new survey.
Mm-hmm.
It has incomplete dimensions. The boat dock is not dimensioned properly. The boat lift is not dimensioned. The distance from the property line is not dimensioned, etc. However, there are dimensions on the drawing of many kinds. And I don't know if you know this or not, but this is a PDF.
Mm-hmm.
Adobe Acrobat allows you to add dimensions to a drawing. And to get them correct, what you have to do is you take an existing drawing, a existing dimension that a surveyor put on the drawing, and then in Adobe, you put in another dimension over the top of that one, and you change the scale of it until it's correct within a fraction of an inch to what the survey says. That then tells you the scale of the PDF, which is always funny, something really stupid, right? Okay. Then you take that in Adobe, and then you can measure any other dimension that you want.
Mm-hmm.
So where the drawing says that the boat lift is 14 feet long, according to the survey, it's 27.5 feet long. Where it shows, for example, the location of the two batter piles that are shown on this applicant's side of the property line, according to the survey, one is on this owner's side of the property line, and the other batter pile is further to the west on the other side of the property line. It raises questions how good this survey really is, how good the dimensions to which the thing was supposedly built are really true. Another issue is the width from the seawall of the wood dock. This seawall contains batter piles. That's clear. The code says in that case the seawall can be no more than 7 feet wide. If it doesn't have batter piles, it's 5 feet wide. According to this, the wood dock that I measured is 8 3/4 feet wide. It doesn't even meet the 7 feet with batter piles. So my issue is, do we really know what we're dealing with as far as the as-built condition? I don't believe it, because the survey is incomplete, the dimensions don't make sense, the dimensions don't agree with what the DEP plan said they based their approval on. It's not clear which plan the city based its approval on, but the whole issue seems to be it's questionable whether or not, as you say, they have a permit that doesn't give them the right to not follow the permit and do whatever they want and not follow the dimensions that you can construe or what the permit anticipated the city was going to get. So I think it's way more complicated than, oh gee, we followed the permit. I'm unconvinced that that's true.
One thing I would just share to kind of help you direct that conversation a little bit. One thing to keep in mind as well is that it is the applicant's burden to present sufficient evidence for the board to make a decision. So if I'm understanding you correctly, you're communicating your frustrations that there's been a lack of evidence to help you find that a variance should or
I'm unconvinced that the data we've given is true to the physical situation. And I don't want to step on you, but I was curious about this. I deal with building permits a lot, but I've never been in this, fortunately, not often in this situation. The Florida law, as I 555.79 or something like that, says if the city or county grants a permit and the permit is approved on the basis of some error made within the approval process, the law says the permit can be removed, and rescinded. There's no, in my view, there's no question under Florida law that the city can't say, well, we made a mistake, sorry, but you've got to fix it to meet the code.
Yeah, and I do want to direct the board away from kind of that analysis or conversation, because quite frankly, whether the permit was previously approved, whether there's construction already done, is completely irrelevant under the 6 elements. And of course, that may be an issue depending on what happens that the property owner and the city will discuss later. But the permit, really doesn't have much of an application beyond just providing you a historic background about how we got here.
I only was curious in looking it up because part of the applicant's justification is that they have an approved permit. That means the city can't take it back. And I understand that that's not true.
My understanding of current law is that is also incorrect. You've been at least presented the evidence in the land development regulations that clearly say that a permit is not an approval to violate other requirements in the code. But yeah, again, I don't think that the permit really has much application to this board beyond a historical context.
So for the east-west condition where it's vessel-based,
Is your mic on? Just want to make sure. There's a red button on the base. Yep.
Oh. Hello?
Yeah.
All right, I guess I've been silent all meeting. East-west, it's vessel-based, and then north-south, it's dock structural-based, right? So if a variance was granted for the west reduction to 4 feet, what is that, like, how is that enforced later? Because that runs with the entire land, but it's a vessel-based discussion. So if code compliance comes out and they've just removed their engines that are an extra 2 feet wide, like, how is that viewed?
Well, it would always be viewed every time they come out. And you're right, maybe the boat was positioned a little further back one day and it's further in the next day. But that's unfortunately if there's a complaint and code has to investigate, they'll come out and they would do whatever measurements or analysis they need to do to determine that they're compliant with a variance if one's granted, or with the 10 feet if one's not. And you're right, it's a unique circumstance in which the encroachment has the ability to move and change over time, but that'd be really a code enforcement issue for them to complete an investigation and make a determination based upon what they see.
But this standard, to be clear, at the bottom of page 2 of your staff report, the standards for boat lifts are kind of what's before you in terms of variances. that when a plot of land, so 799B, says the boat lift shall be located so that the vessel. So the issue is they're asking to have the boat lift located with where it is now, right, with a 10-foot, where it structurally at the 10-foot setback line, so that allowing a vessel to encroach 6 feet. Now the vessel could get smaller, and now it's only encroaching, 5 feet or 4 feet, or it could get bigger. But the point is that the way that it was constructed, the boat lift is in alignment with the end of the dock. I think we can all agree on that, based on the images. Well, the arm of the boat lift is, not the walk around part. So that this arm picking up the boat lift is in alignment with the dock. So to Mr. Cohen's questions about the different plans, the plans, there was one set of plans in the first submission. And those plans were, I think, were the ones that were sent to FDEP when that approval was requested. And then the FDEP, so you see those are the FDEP plans right there, which had more significant setbacks to both the east and the west side. The details of the boat lift show that it projects 20 feet into the water. And then there was a resubmission in response to comments that was labeled reduce the length of the dock. And it did reduce the length of the dock, but it also slid it over, which is fine. The dock is allowed to be there. It's the boat lift now that has set up any boat to be encroaching that is at issue. So ultimately, it's the location of the boat lift. However, I think to Mr. Cohen's concern, staff did ask for the dimensions so that we could try to resolve the issue, the as-built dimensions, which is why this is now another survey that was submitted after the permit drawings to say, okay, it's built now, measure it all, tell us exactly what's where so we can take this forward to resolve it. Quite frankly, normally this board does not see incomplete information, but this has been taking a long time to resolve. I understand the applicant is frustrated, the city is frustrated, the neighbors are frustrated, and ultimately this needs to move forward. And the code enforcement board is staying any kind of action, waiting to make sure that the board considers this. Now, if you don't have sufficient information to grant it, that's fine, then deny it. But we need to unstick the application so that we can figure out a resolution at some point.
Any other questions or comments from anybody on the board? All right. Do we want to go through the criteria?
Okay, the board's ready. I can begin the process. So, as you recall, I'll begin reading the entire board order. There are 6 elements pursuant to land development regulations. Each element needs to be found positive, and for the Board of Adjustments, that means that at least 5 members have to make positive findings for each element. Once we go through the elements, if all 6 are met, then we'll just need a simple motion to approve. If any of the elements have failed, then it would be a motion to deny. There's 2 variances associated with this file. The first variance that I'll read is the side setback encroachment into that 10-foot area. The second one will be extending the lift out beyond 20 feet from the seawall. So the first one is the side encroachment into the 10 feet towards the neighbor. This is a Board of Adjustment final board order for file number 2023-228, date September 7th, 2023, for the address located, or the property located at 942 Evergreen Drive. The request is consideration of a variance from Land Development Regulations Section 7.9.11B to allow a boat lift to be located so that the vessel in its raised position shall not extend any closer than 4 feet to the adjacent property line. Pursuant to Land Development Regulations, Section 2.47A5, following consideration of all the evidence and testimony, the Board of Adjustments for the City of Delray Beach finds as follows. 1, that special conditions and circumstances exist which are peculiar to the land, structure, or building involved and which are not generally applicable to other land, structures, or buildings subject to the same zoning. Diane?
Brenda Cullinan,
Approve.
Jesse Slosser,
No.
Vlad Dumitrescu,
Yes.
Alec Hayes,
No.
Mike Miles,
No.
Robert Cohen.
No.
2, that little interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning.
Brenda Cullinan,
No.
Jesse Slosser,
No.
Vlad Dumitrescu,
No.
Alec Hayes,
No.
Mike Miles,
No.
Robert Cohen.
No.
3, that the special conditions and circumstances have not resulted from the actions of the applicant.
Brenda Cullinan,
No.
Jesse Slosser,
No.
Vlad Dumitrescu,
No.
Alec Hayes,
No.
Mike Miles,
No.
Robert Cohen.
No.
4, that granting the variance will not confer onto the applicant any special privilege that is denied to other land, structures, and buildings under the same zoning.
Brenda Cullinan,
No.
Jesse Slosser,
No.
Vlad Dumitrescu,
No.
Alec Hayes,
No.
Mike Miles,
No.
Robert Cohen.
No.
5, that the reasons set forth in the variance petition justify granting of the variance and that the variance is the minimum variance that will make possible the reasonable use of the land, building, or structure.
Brenda Cullinan,
Yes.
Jesse Slosser,
No.
Vlad Dumitrescu,
No.
Alec Hayes,
No.
Mike Miles,
No.
Robert Cohen.
No.
And 6, that the granting of the variance will be in harmony with the general purpose and intent of existing regulations, will not be injurious to the neighborhood or otherwise detrimental to the public welfare.
Brenda Cullinan,
No.
Jesse Slosser,
No.
Vlad Dumitrescu,
No.
Alec Hayes,
No.
Mike Miles,
No.
Robert Cohen.
No.
This time, can I get a board member other than the chair to make a motion to deny the variance request for section 7.9.11B?
I'll
And you
motion
can-
to deny.
Yeah, great.
Second.
Brenda Cullinan,
No.
Jesse Slosser,
No.
So,
Fine.
just to clarify, this is a motion to deny. So, if you believe the application should be denied, then it's a yes vote. I know that's a little.
Okay, all right, yeah.
we're changing.
Yeah.
Yes.
Yes.
Jesse Slosser,
Yes.
Vlad Dumitrescu,
Yes.
Alec Hayes,
Yes.
Mike Miles,
Yes.
Robert Cohen.
Yes.
Pursuant to LDR Section 2.2.4D7, all decisions of the Board of Adjustments are final based on the entire record before it. The Board of Adjustment denies the variance for the purposes presented at the meeting. Okay. And so I'll do the board order for the second variance request. This is a request to have the boat lift extend beyond the 20-foot limitation from the seawall. This is a Board of Adjustment final board order for file number 2023-228 on September 7th, 2023 for the property located at 942 Evergreen Drive. The request is consideration of a variance from Land Development Regulations Section 7.9.11A to allow a boat lift to project more than 20 feet into the waterway from the seawall. Pursuant to Land Development Regulations Section 2.4.785, following consideration of all the evidence and testimony, the Board of Adjustments for the City of Delray Beach finds as follows. 1, that special conditions and circumstances exist which are peculiar to the land, structure, or building involved and which are not generally applicable to other land, structures, or buildings subject to the same zoning.
Brenda Cullinan,
Yes.
Jesse Slosser,
No.
Vlad Dumitrescu,
Yes.
Alec Hayes,
No.
Mike Miles,
No.
Robert Cohen.
No.
2, that literal interpretation of the regulations would deprive the applicants of rights commonly enjoyed by other properties subject to the same zoning.
Brenda Cullinan,
No.
Jesse Slosser,
No.
Vlad Dumitrescu,
No.
Alec Hayes,
No.
Mike Miles,
No.
Robert Cohen.
No.
3, that the special conditions and circumstances have not resulted from the actions of the applicant.
Brenda Cullinan.
No.
Jesse Slusser.
No.
Vlad Dumitrescu.
No.
Alec Hayes.
No.
Mike Miles.
No.
Robert Cohen.
No.
That granting the variance will not confer on the applicant any special privilege that is denied to other land structures or buildings under the same zoning.
Brenda Cullinan.
No.
Jesse Slusser.
No.
Vlad Dumitrescu.
No.
Alec Hayes.
No.
Mike Miles.
No.
Robert Cohen.
No.
That the reasons set forth in the variance petition justify granting of the variance, and that the variance is the minimum variance that will make possible the reasonable use of the land, building, or structure.
Brenda Cullinan.
No.
Jesse Slusser.
No.
Vlad Dumitrescu.
No.
Alec Hayes.
No.
Mike Miles.
No.
Robert Cohen.
No.
And that the granting of the variance will be in harmony with the general purpose and intent of existing regulations, will not be injurious to the neighborhood or otherwise detrimental to the public welfare.
Brenda Cullinan.
No.
Jesse Slusser.
No.
Vlad Dumitrescu.
No.
Alec Hayes.
No.
Mike Miles.
No.
Robert Cohen.
No.
At this time, could I have a board member make a motion to deny the variance request from section 7.911A?
I make a motion to deny.
Second.
Brenda Cullinan.
No. I make a motion.
To deny.
Yes.
So,
Yes.
again,
Yes.
this would be, it's
A
a yes to deny.
Yes, I mean,
Okay.
yes to deny. Sorry.
Jesse Slusser.
Yes.
Vlad Dumitrescu.
Yes.
Alec Hayes.
Yes.
Mike Miles.
Yes.
Robert Cohen.
Yes.
Pursuant to LDR Section 2.2.4D7, all decisions of the Board of Adjustment are final. Based on the entire record before it, the Board of Adjustment denies the variance for the purposes presented at the meeting.
Thank you.
All right. That concludes the action on this case for 942 Evergreen Drive. When give everybody a chance to leave that wants to go, and then we will proceed to the second case on the agenda, 2022-040, 809 Northwest 2nd Street. So I ask now for any board or member of the board have any ex parte communications to report relative to this case, 2022-040, 809 Northwest 2nd Street.
No.
None.
All right, thank you.
Good evening. I'm Jennifer Buse, planner for the City of Delray, and I just would like to put into the record into file 2022-040 at 809 Northwest 2nd Street. And the applicant is here to present.
Oh, I'm sorry. Hi, I apologize. I'm working with one wing here.
And Mr. Carney, I wasn't sure if you heard them, but they all disclosed they had no ex parte on your item.
I did not hear that, but thank you for the. I wanted to pass this out. This is my name is Tom Carney, 135 Southeast 5th Avenue, Suite 202, Delray Beach, on behalf of the applicant. By way of background, this was scheduled for a meeting in May. There was a staff report generated and published online. Times change, new planner, everything, so there's a new report. But there's some good narrative in this that I was kind of going to be using in my presentation, which I'm not unable to get the kind of presentation I want to now that I would have done in May. So I'm going to pass this out because I'm going to be making reference to it. I have with me the architect and the developers who have purchased in this neighborhood. They're very excited about being one of the early redevelopment in this neighborhood, because this is a neighborhood that's been wanting redevelopment and needing redevelopment, and they've come in and they've agreed to do this. This site is, I love that definition that you put up earlier of what a variance is, because this fits solely within the reason why we have variances. This site is 4,700 square, 4,700, I had it written down on one of the sheets, square feet. And with the 2 feet alley dedication, by the way, there was some misunderstanding with some of those I spoke earlier. They thought we were taking away the alley. In fact, we're adding 2 feet to the alley. So the alley is actually going to be larger than it was. What we are asking for, and the relief we're asking for there, is because when we had designed the house, before we were told about the dedication, the house was set to the standard 15-foot setback, so we're really just asking for a 13-foot setback. The staff reports indicate, both staff reports indicate that that's not really an issue with the city. But this 4,700 square foot, the land development regulations and all the setbacks were really designed for lots, minimum lot size of 7,500 square feet. At 4,700 square feet, less the 140 square feet that we have to give for the dedication, you're really dealing with a site which is 60% of the size that these land development regulations were designed to create setbacks for. So I wanted to go through some, by way of this, I'm going to try to do it with the photos to kind of explain what I'm going to do, as opposed to having, I couldn't really type. So this is the site, as you will see. I want you to take particular note to the curving of the road there, where the site is. But here's where the site is. The alleyway is to the left there. And do I just hit this? Oh, there we go. Thank you. This is the site from the road. As you see, there's a swale in front of it and some shrubbery, et cetera, et cetera. I've done a few of those because I want to explain something later. Again, here is a copy of the lot. You'll see it's a very small lot. It's as I said, it's only 4,700 square feet. By leaps and bounds, it's among one of the smallest in the area, although the property right next door is an equivalent size. This is the west side of the lot. I'm showing you where the fence is because that's the road, that's the alleyway that we're going to be giving 2 feet to expand the width. That's a better picture of it. So you see the alleyway is not going to be impacted at all by this. In fact, as I said, we're giving 2 feet to the alley. This is landscaping which already exists on Martin Luther King Boulevard and the front of this site. And this, again, is looking to the west, so you can see kind of all the space there. And the reason I'm doing this is because when we talk about setbacks, you know, the purpose of setback is to create like the visual effect of space and all this other kind of stuff. You'll see, and it's not as big as it would be, I would like, but in the western part of to the outer part of the swale, you really add 17.5 feet to the property line. To the eastern part there, you add another 25.5 feet to the property line. So when we're talking about reduction in front setbacks, you know, I hope we take into consideration the fact that there already is huge property open space in front of it that's from the city, and it's improved property and been part of a landscape plan of the city, and which, by the way, is going to continue to undergo improvements, I hope. Here is the original survey. Here is the site plan, which, again, I'm sorry, I wish I had your skill with the PDFs and doing all that stuff, because I really don't know how to do it, and my secretary is gone this week because I told her, quote, nothing's going on. Well, at the time, I thought the meeting was in May. So, but you can see that in the entire structure there, our rear setback is 10 feet. We have 10 feet in the rear, and you can see there's 2 little lines there. I hope the picture is better where you are. There's 2 little lines there. One shows where the actual property line is, and the other shows the giving of the 2 feet to the alley. So, as I said, when we first developed the property, it was with a 15-foot setback. They came in later and said we had to give 2 feet away, but now the property's already been designed and everything's going forward. And frankly, and in meetings with the city, the 2 feet really was, in fact, they said it in one of the staff reports, I don't know which one it was, but essentially that it really didn't have any impact at all on the alleyway, and they did not deem it as a negative. That's a little bit more of the same, gives you a little bit of the mumbo jumbo in the upper left about various size. It's not a very big house to start with. This is the same picture, and I don't understand why it's there. This is what the house is going to look like. You'll see where the swimming pool is. The swimming pool is going to be behind a wall, so it's not going to be visible from the street or sidewalk. There was a concern, you know, that in terms of the visibility, and I read a letter talking about the safety where people could get into a pool and they could jump into the pool. This is going to have a wall around it, and so it's really it's protecting two things. First, when people are walking by, they're not looking right into the pool because the wall's there, and secondly, it does provide a deterrent for if someone's going to climb over the wall and do it. Now, wherever that pool would be located on a property, if someone were going to climb over the wall, they would climb over the wall. But I will say that this is the only place that the pool can go. And in Florida, having a pool as part of a house is kind of a general amenity. And not to have one really is kind of depriving the applicant of something that other people can do. And had the lot size been any larger, we could have put it into the back or to the side. But as the reality was, with a 10-foot backyard, if we'd moved the pool to the backyard, with the 25 feet front setback, we're left with a house with a depth of maybe 30 feet, give or take. And as you know, the lot is only 60 feet wide, so you're really not left with more than just a big, maybe 2-story container box. So that is what we're talking about. This is that's just another rendering showing what it kind of look at night, with the how it's going to look. And this is. I did this picture at the very end as a as an example. One of the portions in Dr. Wright's letter talked about how they were looking in this area to have this setbacks, made 5 feet all along the entire area, all the way from 9th to 11th or 12th. And the reality is, the whole purposes of variances is to be able to take a unique property, deal with that unique property, and create a rule as it relates to that one property. If you go along that whole street, all the property sizes are not this small, so having a multiple blocks with a change to 5 feet would have actually been something which would have changed dramatically the neighborhoods, because some properties would need it, others might not. And the reason we have the code and the ability to obtain variances is for those who really do have trouble. They can come in front of a board and explain it and show their equities and essentially get the deal done when people understand exactly what they have. I want you to notice, though, that the road, I'm going back to that road, and I only go back to it because of the actual, really, how much space there is in between the property line and the road. And there's a considerable amount of space between the property line and the road. So I'm going to go through, if you go through the handout that I handed you, you'll see that there was a variety of stuff which I highlighted. And you're welcome to check the highlights, but they're mine. And we're really talking about, as it relates to both, the factors that you have to do in order to approve a variance. And in the first little A there, which is what I was going to be having on my presentation, was essentially saying that because of the size of the lot, it really makes it difficult to construct anything, and that the variance request that we are looking for, this is the staff's language, not mine. The variance that we're looking for is the minimum setback. It's a minimal variance, and we're asking for relief from two sides, which resulted from the 2 feet dedication. We're not looking, if we'd not given that 2 feet away, we wouldn't have had to ask for it, but since they took it, and since it doesn't really affect the alleyway at all, and as I said, staff even in their latest staff reporting towards the end there kind of also mentioned that it really doesn't affect it. Their words are somewhere there. Well, I can't. I mean, I usually have the ability to move around a bit, and I'm having trouble here. And I would take my thing off, and then my wife would see me on the tape, and then she'd yell at me for not following the rules. I'm having to deal with that issue every day. So, which is true. Yeah, but they say in the last page of the most recent staff report talks about that the side street setback adjacent to unapproved alley that will not affect the surrounding neighborhood. And you can see on that depiction the actual area that we are talking about having the relief from, and it's that portion that really is really from the house. Actually, that shouldn't really have gone all the way to the back because we don't really have a structure back there. But anyway, that is the area where we are looking for relief. The other is the visual interpretation would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning. Well, other properties subject to the same zoning are kind of 7,500 square feet. So there are really no other properties with the same zoning that are in the same situation as us in terms of the size of the lot. So it's really the size of the lot which is driving the need for both having the swimming pool in the front, as I said, we only have 10 feet in the back, and the side setback relief, having given the 2-foot dedication. Well, we know that obviously this is not conditions that were circumstances that result in anything that we did. This was obviously something that was done before we were even here, at a time when they were cutting up lots to make all kinds of stuff, and these days this would not happen, I assure you, in Delray Beach, where we would create these really dramatically non-conforming lots. It's just not non-conforming, it's really non-conforming. It's like a postage stamp. The reasons set forth in the variance justify the granting of the variance. Without the variance, there really could be no reasonable use of the land, because you wouldn't really be able to build any kind of house which would have the normal amenities that you expect to have in an R1A neighborhood, which would be the pool, which would be, the house. I suppose, nobody's really suggesting you should have to build a tiny little property there in order to comply, because it really doesn't make any sense on the property. The granting of the variance for the side setback will not result in any detriment to the neighborhood. I've already explained that. And the swimming pool will be. This is the city saying the city will be hidden behind a 6-foot privacy wall, which will shield it from neighbors, passerby vehicles, and pedestrians alike. And as I said, there is no other place for the swimming pool other than the front. We've done it as best as we can by putting a wall around it, tastefully done. The landscaping is tastefully done. It will certainly add value to the neighborhood. This is, as I said, this is a neighborhood that really should be redeveloped, and there's a lot of opportunities to redevelop it. With the relief that we're asking for the alley, as I said, that's really is not a big issue for anyone. So it really is the ability to utilize a portion of your front setback for building the swimming pool. And as I said, without utilizing the front setback, we have no ability to do a pool at all. So I'm going to wait till everyone makes their presentation. As I said, I have the builder here and the developer here. Should anyone have any questions? I think I'm done, right? Okay. And I thank you for your time. We'll talk to you later.
Thank you.
Hi, good evening, Jennifer Buse again. I do want to mention this, as you see, this is a file number from a year ago. It's 2022-040. This came in with one variance, and at the beginning it was for the pool. And as we started to review the application, it became 5 variances and a waiver. And so at this time, it has been reduced down to 2 variance requests. This is a variance request, LDR 434K, which is our development standard matrix, and this is to allow a 13-foot side street setback where 15 is required, and LDR 4615G1 to allow the swimming pool to encroach into the front setback at 15 feet, whereas a minimum of 25 is required. This isn't a vacant lot. The proposal is a single-family residential home. It is in the R1A zoning district. It is surrounded by R1A, except to the south is community facilities. So a little bit of background on this. As you can see, to the left is the original plat of Torres Nook. It was block A and B, and it was developed in 1927. I did a side-by-side so that you could see that a lot of the lots remain in the original configuration, which makes these a non-conforming lot of record in the R1A zoning district. Few of these lots do, at this time, meet the R1A zoning district standards. So just to show here that the alley is platted at 16 feet. It is unimproved at this time, but they do have in the future improvements to improve and pave this alley. Again, if anyone here redevelops on either side, they would also be required to give the 2 feet dedication. This is this is the site plan, and it shows you where the 13 feet is being requested in the red. The pool is in the blue, and the gray area is where the footprint of the home. And again, this is just the variance is a relaxation of the terms of the LDRs, where such variance will not be contrary to the public interest and where owing to the conditions peculiar to the property and not result of the actions of the landlord. So here are your findings. Once again, special conditions and circumstances exist which are peculiar to the land, structure, or building involved. Whether the literal interpretation of regulations would deprive the applicant of rights commonly enjoyed by others, and that the granting of the variance will not confer onto the applicant any special privilege that is denied to other land structures and buildings under the same zoning, and that the reasons set forth are the minimum or petition justify the granting of the variance, and that it will not be injurious to the neighborhood or otherwise detrimental to public welfare. And I believe that concludes my presentation. There are 2 board actions.
Thank you. Are there any comments from the public on this case?
Yes. Good afternoon. My name is Ernestine Holiday.
Just remind me.
I also live in.
You have 3 minutes. You'll have 3 minutes.
She knows.
You don't understand? I just want to make it clear.
Excuse me? He said that you have 3 minutes to speak.
Oh, I know.
Thank you.
I'm very familiar. Good afternoon. My name is Ernestine Holiday. I am also a resident of West Side Heights, which this property is in. A year ago in May, I needed a 5-foot setback on each side of my property to have a new house built. I have owned that property since 1964. I had a house there that we demolished and wanted to rebuild. With my neighbors approving of the 5-foot, 2.5 foot on each side, I was denied. We had to find a new plan, a new house to be, a new, whatever. But anyway, this property at 809, this is a very narrow lot. And everything on 2nd Street, Martin Luther King Boulevard, requires a 25-foot setback. Why would this person be allowed to have 15 feet? To me, that is not in compliance with the street. If I couldn't have a 5-foot setback on a side street, this means Main Street that runs from the Intercoastal Waterway to the wall of I-95, why should they have it? This, in other words, everybody that has a pool in Delray in the neighborhood from Swinton to I-95 is either in the back or on the side. A pool in the front yard, would you want one in your front yard? I don't think Mr. Carney would.
Thank you.
Good afternoon. Ann Stacy Wright, 225 Southwest 7th Avenue. Mr. Carney mentioned about his children in the neighborhood. There would be a wall, and that there would be They won't be able to see what's behind that wall. I don't know about you all, but I've worked with some very curious children. And to see a wall is only going to pique my interest to go and see what's behind that wall. We have children that walk to and from S.D. Spady Elementary School. We have children that participate in the activities at Pompey Park, which are the youth football, Delray Rocks football, the baseball, cheerleader, aftercare, and all. My concern is I don't want to see in my neighborhood a bunch of houses right down the street and see a bunch of houses with some walls built around it. I don't think you would want it in your community where everybody, you ride down and every time you see there's a wall everywhere. And so, as far as the property, and my thing is that when they purchased the lot, they knew the size. They knew the variances and different things that they would run into. And I don't think that is fair to our community to have that set. We're not against him having a pool. We just don't want it in the front yard. That's our concern. We don't want it in the front yard. I don't know if they noticed, but down 2nd Street from Swinton all the way down to I-95 wall, there are 5 homes with pools on that street. But you wouldn't know that because they're located in the back of the homes. So why not with this one? I ask that you not approve this variance. Thank you.
Thank you.
Good evening. My name is Carolyn Young. I own property in this area, and I am speaking against you giving the variance for this. One, I'm in favor of the redevelopment, but not in this manner. Pool was nice to have a home, but not in the front, and it is incompatible with the other homes in this area. If you're going to have a pool, I would think because of safety issues, you would not be allowing less setback than what is required. You have those setback requirements. I'm sure safety and everything else is a part of your rationale for having that. First of all, the structure is just incompatible. The house and with the pool in the front, it just doesn't sit well. The other thing, it does present a safety hazard for the children. And there are a lot of children in that neighborhood, and they're going to and from Pompey Park. They're going to and from Spady Elementary School. And I agree with the previous speaker. It will pique their interest to see what's behind that wall. And therefore, it presents a safety hazard. And we would not like to have that kind of incident to occur with our children. So I'm really requesting that you deny this, and perhaps they can look at a different kind of footprint that would have a pool in the rear if they can accommodate it. If not, then they have to put a different footprint of a house. You know, there are requirements for that you have to meet to build a home, and I think that those requirements should be used in allowing them to build their structure. I'm not against them building, but within the guidelines. Thank you.
Thank you.
Good evening, Board. Reggie Cox, 715 Northwest 2nd Street, Indoor MLK Drive. I agree with all the speakers. There are some things said by the counsel for the applicant that is incorrect, but I suppose that goes beyond the scope. For example, most of the lots in this area is 5,000 square foot. I mean, only 300 square foot bigger than this. You know, you got a 50 by 100 lot. Some of them are 50 by 135, but you know, these lots were platted many, many decades ago, okay, and that R1A designation came way after, okay. due to zoning and zoning changes over time with land use and stuff like that. This is a community of families, okay, a community of generational families, well organized, represent 20% of the voting population, the active voting population in Delray Beach, which is known as the set, 1,000 acres. This is the north side. The adjacent owner, who's not here, did write a letter, Dr. Deborah Wright, for some of the issues that the other speakers are against it as well. And kids would actually get curious. The thing that you're here for, though, is approving the variances or denying the variances. I'm requesting that you deny both of the variances because I don't see a special condition whatsoever. It's been a non-conforming lot for years. When they changed the designation, there was a house there before. There was a shed on this property before. It's really a function of design, okay, to what you want to have there. Ms. Young mentioned it doesn't fit the character of the neighborhood, which goes to your item number F in your findings as far as harmony. So it does impact the neighborhood. Is definitely not contextual. That's why I believe the applicant didn't show any adjacent houses or any elevation or any contextual views to show how it would fit in the fabric of the neighborhood. So the harmony is not there. We don't want to turn into a commercial street with setbacks. I don't know where you got 5 feet proposed setbacks. I never heard of that before. I sat on this board 20 years ago, so I know what you all go through. But as far as your findings is concerned, here again, there's no special condition. Nobody on that streets, like the other speaker said, has pools in the front. Here again, that's a contextual issue. Like I say, it's really more of a design issue, and none of these findings, inclusive of the first one, as far as a special condition, these variants, I believe, meet as far as some of the technical aspects of what you all are looking at, and that's before you. So, here again, it's a well-organized neighborhood. Westside Heights Neighborhood Association was not.
Thank you. Your time is up.
Oh, sorry about that. Sorry about that. But anyway, thank you, and asking for a denial. Thank you.
Good evening. My name is Dr. Jerome Burke, and we live at 230 Northwest 7th Avenue. We are a family, a Stratford Burke family, and I want to read this into the minutes. Good afternoon. I'm writing to oppose the variant request for 809 Northwest 2nd Street. The variance request of the yard encroachments to allow a swimming pool in the front yard is not compatible for the safety of the neighborhood. Many children live within the 500 feet radius of 809 Northwest 2nd Street, and a swimming pool in the front yard poses a significant safety concern. Additionally, many people walk from Pompey Park along the sidewalk in front of 809 Northwest 2nd Street to the respective homes within the neighborhood. The proposed variance request also does not provide more housing within the neighborhood, which is much needed. A swimming pool is not needed at the single-family house as there is a swimming pool at Pompey Park. I would also like more information on how this request will affect our property. The other concern is, again, having a swimming pool in the front, again, it's not conducive for children's safety. And if you're talking about a full-size swimming pool, they have lap pools now, 10 by 8. You can put those in the backyard. It's not a problem. If you want to have a change in the size of the house, that's also appropriate for the neighborhood. I could go more into it, but if he's trying to sell the house 1.3, 1.5, it's not going to sell. If he wants to look at Airbnb, it's not going to be profitable because there's several Airbnbs around the place that are empty. So this is not going to enhance the property value at all. Thank you.
Thank you. Is there anyone else from the public? Hang on a sec. Okay. Are you're going to make a rebuttal
Are you
of some
calling for
sort?
a rebuttal?
All right,
Yes,
yeah.
thank
All
you.
right, we're ready. Thank you.
Okay, just checking. First of all, I wish our property was 50 by 100, Reggie, because then we wouldn't be needing the pool in the front. It would be certainly have ample room for it in the back. But the reality is it's not. It's 60 feet. So we have two choices: to not put a pool at all, which would then be essentially denying an amenity that most people try to have in Florida especially, or we try to build it as best as we can and making it as safe as we can and as aesthetically pleasing as we can. And again, the building is still 25-foot setback. We're really talking about building within the setback area. I mean, you still have the visual distance between the property line and the house of 25 feet. I'm not sure whether the safety issue, I'm not getting into all the details and rebut every point by point, but you know, this is against an alley, so they're going to be any less inclined to climb over the backyard wall to get into the pool off the alleyway, which is public space, than they are the sidewalk? I really don't know. I think that's kind of a far-fetched argument. By the way, Airbnbs are not really allowed. You can have Airbnb in Florida as long as you can only rent 6 times a year in a residential neighborhood. So the concept of trying to have a commercial Airbnb here is just like a non-starter. The vacation statute protects them for 6 times a year, but it's an R1A neighborhood, so they can't really have it. The relief that we are seeking on the side really is only as a result of the dedication that's required against the alley. We're giving 2 feet away to the alleyway, and we're just asking that the design of the structure remain. It doesn't. Everyone has agreed it doesn't really affect the alleyway, so I don't understand why that's even an issue at all. But so the question really is whether or not the pool should be in the front of the house or the back of the house. I will say that a lot of houses, including one I am designing with a pool in the front, are having pools in the front, largely because of the way setbacks work and largely because of the way spacing works generally with some of the lots. So pools in the front of the properties are coming. In fact, one was approved by this board a month ago, allowing to build within the front setback in 25 feet. You allowed people to build things, and I mean, I have countless examples if you'd like to know that. The staff even stated in their report that, you know, this is commonplace in properties of this size. The architect would like to, there was a couple of design questions raised. He'd like to just get up here and say a few things as part of my rebuttal.
So, Tom, are they architectural in nature or where the pool's located?
It's where the pool, yeah, it's
Okay.
the reason why the pool is located.
Okay.
Correct. We're not getting into architectural things. I'm not getting into a SPRAB issue. I'm not getting into design. I'm not getting into anything. I'm getting to why the pool is where it is.
So, yes, hello, my name is Abhi Kanthan, Kanthan Design Corporation. I'm the architect for this project. I just wanted to discuss the safety issue regarding the pool because this was submitted. So on the site plan, we stated a code reference for Florida. So in Florida, there's a protection for anytime you have a pool, you have to provide a barrier around the pool. In this situation, the barrier that we are providing is a solid concrete wall in the front that has been spoken about. The wall is actually 6 feet high. I don't know if that was mentioned, but that is something notable to note. So for a child, a 6 foot high wall is different than a 4 foot tall fence. So we are going taller. And there's also a landscape barrier in front. So in order for somebody to climb this wall, they would have to go through a landscape buffer, climb a 6 foot high wall, and then go into the pool. So we are in safety compliance with the laws of Florida regarding pool safety, and we're going taller than what we are required to do per that law. I just wanted to put that into the record.
And again, we are in compliance with the front setback fully, with the rear setback. the setback to the eastern side of the property, and we were until the dedication on the western side of the property. And again, we're only asking for that relief on the western side because we gave the 2 feet away to create a wider alley that's going to be part of the redevelopment improvement plan for the entire neighborhood, which we all support. Anyway, I'm here to answer any other questions that you may have.
Does the city have any rebuttal?
Yes.
No. I mean, it's, so I don't know if you heard, Chair, but someone from the public asked to make another comment. I mean, public comment at this point has been closed. If the board, a majority, want to afford more public comment, but generally speaking, the city does not engage in that because then everybody would have to be afforded the same opportunity.
All right, so I'll start from the city. Jennifer may want to add something, but because some of the speakers requested more information, I think, about the front setbacks or the setbacks. So the lot right now, the front setback is along the street and it's a minimum of 25 feet. The interior side setback here is 7.5 feet. Because this side is currently being treated as the rear, it's 10 feet. And this side, I have to tell you, has been the subject of a lot of discussion internally about how we handle lots like this. As a interior side, it would need 15 feet. The dedication, as I call it frequently, if you've seen me present these things, the invisible line is moving in order to provide for a wider alley over time to facilitate movement and all of the things that go in those alleys. They're workhorses. There's a lot of things back there. And so the request is to have 13 feet on the side. So the lot, which is an odd configuration compared to the rest of the historic plat, right? When you look at the neighboring properties along the same alley, they would only have a 10-foot setback because when it's a more conventional plat of the long, narrow blocks, they're always the rear. So even treating it as a side setback with the relief, it's 13 feet, where the neighbor directly adjoining this would only have to give 10, so it's fairly consistent, and that is part of why staff hasn't raised as much concern with that. We are going to start an effort in the coming fiscal year to look at the eastern neighborhood setbacks because ultimately the plats that exist are not consistent with what the standards are for a lot of the R1 districts. The West Atlantic Master Plan has advocated, as does the comp plan, for accessory dwelling units and other things. And so we are going to look at these plats and the rules moving forward because we know the older neighborhoods actually don't conform very easily to the rules. And this lot is also just, I don't think I would even have considered how to treat one of this configuration. So I just want to make that clear. That's part of why staff has not, that invisible line shifting. We want the alleys over time to improve and serve the whole neighborhood, and it's not evident. And then in terms of the pool variance, and I'm glad that the architect spoke to the Florida Building Codes requirement, I do want to make it clear that the minimum standard, because you're not looking at the design, is only a 4-foot fence barrier. The city actually does allow, outside of the historic districts, the enclosing walls or fences to be 6 feet. If you're in one of the districts, they're only allowed to be 4. But here, whether there's a pool behind the wall or not, the wall is allowed. And if, I personally agree with the comments of the neighborhood in general, and question whether citywide that should be reconsidered. It was discussed as part of the Osceola Park neighborhood plan in terms of the recommendations that neighborhood having the 6-foot walls maybe was not desirable, but there has not been a change in the rules. So it is the applicant's right, whether there's a pool or not behind it, to put a 6-foot wall. And I just wanted to make sure that everyone knows that. So even if the pool's not behind the wall and the wall comes up eventually, they understand that right now that's allowed through the LDRs. Jennifer, do you want to add anything?
I just want to add that as far as the harmony goes, you're looking at where the setbacks are being taken and with the neighborhood. You're not looking at the architecture of the home at this time.
Anybody on the board have any questions or comments?
So there, I just want to say, so there's no way that the pool can be in the back? I mean, there's not room at all? I mean, if the pool even had to be a little smaller?
So, and I think that's if you look at the aerial, like
Okay.
that's the issue about the lot is what really is the back. Clearly the street is the front, right? And then when you zoom, because this piece got divided up weirdly, right? This is clearly the front, that's where the street is. If this is the front, then this is the back, which is only a 10-foot setback. But if you look at the neighbors, right, their back is to their side, his side is to this lot's back. It's a little bit, of a distinction. Now for the side and the rear setbacks, it's not a big difference. It's 10 feet versus 7.5. The alley, if the alley is considered a side street, it's 15. If it's considered a rear, the way it would be for the rest of the lot, it would only be 10, and even giving the dedication, it's in excess. So right now, the pool would have to go here, or if this is considered a rear, it could possibly go here, but as a side street setback, it would still require a relief of some sort. In any district in the city, any district, if you are going to put a pool in the front setback, you need a variance.
What about the side and the rear?
This side, no, you're allowed.
Yeah, it would still have to be, in the side and the rear, it has to meet a 10-foot setback. So regardless of where they try to put the pool at this time, they're going to be looking for relief. If they push the home forward, they're looking at a front relief for a front setback. And the same as far as if it went on to the side of the alley.
So the gray square, which represents the footprint of the house, has a 25-foot setback from the street, 7.5 from the side, 10 from the rear, and then it had 15, but when the alley movement goes, it goes to 13.
Is there anybody on that block itself that has a pool in the front? Or would this be the only house with the pool in the front?
We have to look at this individually, I think,
Okay.
anyway, so.
All right.
I mean, in terms of the character of the neighborhood, just looking at the aerial, there is not another
Okay.
pool in the front nearby.
So the road obviously jogs weirdly as compared to the original plat that the applicant brought up. My question is, if they pushed the house to the south and requested relief on a front setback to put the pool in the back, the driveway gets smaller. And there's going to be a long driveway to connect to the road. Is a homeowner allowed to park in a driveway that's in the road so long as they're not blocking the sidewalk?
They're also allowed to use the alley.
Right, and in this instance, the cars cannot be in the front setback. I believe they do have the 2-car garage right now, which is going to house the cars, but your required cars cannot be in the front setback.
Okay, so they can't even technically park on the driveway itself, the 25-foot driveway?
Technically.
Okay.
Obviously, guests will come, things happen.
Sure,
Christmas.
no, understood. I'm trying to think of how they might be able to, bring the house forward, request that relief, because I've heard a lot of concerns related to positioning of the pool, not necessarily the pool itself.
Yeah.
And to your point, the wall can be constructed, so that's not really in.
There's a lot of,
Maybe
we've had this
here is
case
better.
many times, and there's confusion as far as you have to have the 2 permanent parking spaces, but it doesn't mean you can't park in your driveway. You can still park in the driveway, okay? That's the permanent space that's got to be far enough away, so you've got the garage in this case. My question is similar, but it's kind of funny. On the site plan, what's interesting to me, intriguing, it just shows the building up to the sidewalk, and there's this additional space in front. Normally, setback is measured from the road. Why is the setback
No,
measured here?
setback is always measured from the property line.
You're thinking of base building line.
Yeah.
Okay, but no.
So in this
I
instance,
understand, but there's this additional space between the house and the street because of the shape of the street, and somehow they're denied the use of that, and they're going to have to build their driveway across that, which isn't, by the way, the driveway doesn't even show going all the way to the street on the drawing, so I'm not sure how wide the driveway is going to be all the way to the street. It's just shown up to the edge of the sidewalk, and what the impact there on the street itself, because the next door driveway is pretty close up to the boundary line. The other question I've had is if a pool was put in the side setback and or the rear setback, what is the setback requirements for the pool itself?
It's 10 feet from the property line.
Okay, so and that's on the side. In this case, the side setback, which is now going to be 13 feet. What's the side setback requirement to the pool?
It's 10 feet. It's 10 feet from the property line, from the rear, the side street, or the side interior.
Okay, so there's really no space in the back unless you did something exotic with the house. Okay. The other question I had, the concrete wall is shown on the site plan as in the front and along the driveway and but there's no indication of a fence to the rear of the house, along the alleyway or from the concrete wall to the house itself. There's no fence, so to me, the pool is not completely within a fenced enclosure as shown on the drawings. So how's that really going to be?
It's shown on the elevations,
but at the time, all right, because we got to be careful with the elevation issue. But at the time of building permit, they would certainly, and this is part of what I want you to consider as well, is that the minimum standard for the wall is 4 feet by the Florida Building Code. We would ensure they would not get a building permit for the pool if they were not fully enclosing it with some type of 4-foot barrier. But you cannot sort of guarantee that it's going to be a 6-foot wall. I can guarantee you it will be enclosed, whatever it is for the pool.
I just was curious why they didn't bother to show what kind of including. I'm kind of curious where remarks were made about maintaining the look of the streetscape. Well, I don't think the house does that by any stretch of the imagination. Also, this elevation is kind of a funny thing. It's a rendering, so we don't know.
So, and I would just completely stay away from that because you have no authority or control over.
No, they were trying to illustrate, what they were trying to do, and I understand the value of it, but it was it doesn't seem, it's kind of off the wall. Okay.
Related to the harmony of the neighborhood, do we know how far the front setback is to the house that's built to the east on a similar sized lot? Because it looks like it's pushed forward compared to 25 feet.
Well, and remember the front would actually be the avenue, not Second Street.
For them it would be?
Yes.
Well, because this is the bigger road, though.
Yeah,
it's vehicular access. There's all the rules.
No.
And this is part of where the lot configuration issue really does get tricky, right? Because the driveway's here. Now, if they had a limited access agreement, we'd say it was the front. But normally for single-family homes, this is part of what I want to look at with the reconsideration, which is sort of the narrower lot is almost always the front. And while we want mixed use and commercial to turn towards the collectors and the arterials, single-family really should put its side to it. It's just a little bit more insulated then. Nonetheless, the front depends on a lot of factors. So here's another corner lot. Right, so because this is a collector and here's the driveway, this is the front, this is a side street, this is their rear. The house behind this, the front is 9th, 2 interior sides, and a rear to the alley, the same here. So, when the grid gets kind of broken down like these two, it can be tricky to figure out the best solution. So the solution that's being brought before you is if this side is considered a side street and they give the alley dedication, if there would be some relief to allow 13 feet instead of squeezing it that much more. And then the rear is being met to the north, right? Sorry, I'm not moving. And the side of 7.5 is met this way, 25 feet is met this way. So that's one consideration. The second consideration turns to whether the pool can be there or not. So they're two separate. You could approve one but not the other.
So my final question for staff and then I guess closing statements for the board. Is Northwest 2nd Street fully built out per the comp plan, or are there widening improvements slated for that? Do you know?
I mean, there might be improvements, but we're not gonna widen it.
No,
Okay.
and if it's not to the size that it's supposed to be, I believe it's 50 feet, then again, if there's new construction that's going on, then at that time, the applicants or whatever property it is would have to give up that many feet to make it 50 feet.
There's no dedication required for second with this.
So, I mean, I'm inclined to support the side alley dedication relief. I mean, we've seen a lot of that. I'm not sure personally on the pool setback, because I do think there's, you know, hearing the neighbors as well, taking that into consideration, you may have an opportunity to push the building forward because you have such a long driveway and fit the pool in the rear. You may want to consider that. It's just a suggestion. I don't know which way I would go on this vote, so I don't know how the rest of you feel.
I feel the same about the pool in the rear too.
Yeah. I would think granting the side setback would allow them to build, but it would, I think without the front allowance, they're just not gonna have a pool, which may or may not be acceptable to the owner or the potential owners.
And the variance stands on its own. It's not variance condition on a 6-foot wall, right? You can't do that. Okay.
No.
I would really advise against something like that, especially if the building code already addresses it on some level. Technically, a computer died, but I think technically the code does allow you to place conditions on a variance, but I don't think something like that would be appropriate in this instance.
Okay, thank you.
So we need to do with the two variances separately?
Yes, we'll do them each individually, just like we did the last one. Okay. Looks like we're starting with the side setback reduction from 15 feet to 13. This is the Board of Adjustment Final Board Order, file number 2022-040, September 7th, 2023, for the property located at 809 Northwest 2nd Street. It's a consideration of a variance request from Land Development Regulations, Section 4.3.4K, to allow a side street setback of 13 feet. Pursuant to Land Development Regulations, Section 2.4.7A5, following consideration of all the evidence and testimony, the Board of Adjustment for the City of Delray Beach finds as follows. 1. That special conditions and circumstances exist which are peculiar to the land structure or building involved and which are not generally applicable to other land structures or buildings subject to the same zoning.
Brenda Cullinan?
No.
Jesse Slosser?
Yes.
Vlad Dumitrescu?
Yes.
Alec Hayes?
Yes.
Mac Miles?
Yes.
Robert Cohen?
Yes.
I'm sorry, Mr. Cohen, that was a yes or a no?
Yes.
Okay.
Yes. Sorry.
2, that literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning.
Brenda Cullinan?
No.
Jesse Slosser?
Yes.
Vlad Dumitrescu?
Yes.
Alec Hayes?
Yes.
Mike Miles?
Yes.
Robert Cohen?
Yes.
That the special conditions and circumstances have not resulted from the actions of the applicant.
Brenda Cullinan?
No.
Jesse Slosser?
Yes.
Vlad Dumitrescu?
Yes.
Alec Hayes?
Yes.
Mike Miles?
Yes.
Robert Cohen?
Yes.
That granting the variance will not confer unto the applicant any special privilege that is denied to other land structures and buildings under the same zoning.
Brenda Cullinan?
No.
Jesse Slosser?
Yes.
Vlad Dumitrescu?
Yes.
Alec Hayes?
Yes.
Mike Miles?
Yes.
Robert Cohen?
Yes.
That the reasons set forth in the variance petition justify granting of the variance, and that the variance is the minimum variance that will make possible a reasonable use of the land, building, or structure.
Brenda Cullinan?
No.
Jesse Slosser?
Yes.
Vlad Dumitrescu?
Yes.
Alec Hayes?
Yes.
Mike Miles?
Yes.
Robert Cohen?
Yes.
And that the granting of the variance will be in harmony with the general purpose and intent of existing regulations, will not be injurious to the neighborhood or otherwise detrimental to the public welfare.
Brenda Cullinan?
Yes. On that.
Jesse Slosser?
Yes.
Vlad Dumitrescu?
Yes.
Alec Hayes,
Yes.
Mike Miles,
Yes.
Robert Cohen.
Yes.
At this time, the Board of Adjustments, by the appropriate number, has found positive findings for all 6 elements. Can I please get a motion to approve the variance request from 4.3.4K to allow the side street setback of 13 feet?
So moved.
Second.
Brenda Cullinan,
Yes.
Jesse Slosser,
Yes.
Vlad Dumitrescu.
Yes.
Alec Hayes,
Yes.
Mike Miles.
Yes.
Robert Cohen.
Yes. I didn't hear who the second was, I'm sorry.
That was me.
It's down there.
Okay, thank
Yeah.
you.
Oh, I'm good. Thank you. Yes. Okay. And then our second variance request, this will be regarding the pool in the front setback. This is the Board of Adjustment final board order for file number 2022-040 from September 7th, 2023 for the property located at 809 Northwest 2nd Street. It's a consideration of a variance request from Land Development Regulations Section 4.6.15G1 to allow a swimming pool to extend 15 feet into the front setback. Pursuant to Land Development Regulations Section 2.4.785, following consideration of all the evidence and testimony, the Board of Adjustment for the City of Delray Beach finds as follows: that special conditions and circumstances exist which are peculiar to the land structure or building involved and which are not generally applicable to other land structures or buildings subject to the same zoning.
Brenda Cullinan.
Yes.
Jesse Slosser,
Yes.
Vlad Dumitrescu.
Yes.
Alec Hayes.
Yes.
Mike Miles.
Yes.
Robert Cohen.
Yes.
That literal interpretation of the regulations would deprive the applicant of rights commonly enjoyed by other properties subject to the same zoning.
Brenda Cullinan.
Yes.
Jesse Slosser,
Yes.
Vlad Dumitrescu.
Yes.
Alec Hayes.
No.
Mike Miles.
Yes.
Robert Cohen.
Yes.
Diane, I missed one that's 5 yeses and 1 no.
Yes.
Correct. Okay, thank you. That the special conditions and circumstances have not resulted from actions of the applicant.
Brenda Cullinan.
Yes.
Jesse Slosser,
Yes.
Vlad Dumitrescu.
No.
Alec Hayes.
Yes.
Mike Miles.
No.
Robert Cohen.
Yes.
That granting the variance will not confer onto the applicant any special privilege that is denied to other land structures and buildings under the same zoning.
Brenda Cullinan.
Yes.
Jesse Slosser,
Yes.
Vlad Dumitrescu.
Yes.
Alec Hayes.
No.
Mike Miles.
Yes.
Robert Cohen.
Yes.
That the reasons set forth in the variance petition justify granting of the variance, and that the variance is the minimum variance that will make possible a reasonable use of land, building, or structure.
Brenda Cullinan.
Yes.
Jesse Slosser,
Yes.
Vlad Dumitrescu.
No.
Alec Hayes.
No.
Mike Miles.
Yes.
Robert Cohen.
No.
And that the granting of the variance will be in harmony with the general purpose and intent of existing regulations, will not be injurious to the neighborhood or otherwise detrimental to the public welfare.
Brenda Cullinan.
Yes.
Jesse Slosser,
Yes.
Vlad Dumitrescu.
Yes.
Alec Hayes.
No.
Mike Miles.
Yes.
Robert Cohen.
Yes.
So the Board of Adjustments made findings that the variance failed under the special conditions and circumstances, as well as the reasons set forth in petition justify granting of the variance. At this point, can I please get a motion to deny?
Motion to deny?
Second.
Just a reminder, this is a yes to the denial. And technically, since the board, as a board, you found that the petition was not justified, you should vote to deny or confirm the denial by vote.
Point of order. Can we not have this vote, bring this second issue back up at the next meeting?
I think the problem at this point is that the board's made their findings.
Yeah, but until there's a final vote, there's not a final vote. They can always change their finding votes. I believe I'm correct on that.
I would direct the board to make the motion tonight.
Because denying this property in this neighborhood is not a good thing.
There could be a motion for reconsideration at the next hearing. because that would be the next hearing after the motion was made. But at this point, the board has made an official finding that the petition does not satisfy the elements. I don't.
Well, the same elements that they approved one last month someplace else at a larger lot.
And like you just said, a larger lot. So they're all different. They're all unique.
I understand,
they're all
I understand that.
individual.
I understand that.
So,
I understand that.
But that's what the board has found tonight. Yes.
Can I speak?
This
is a huge mistake.
At this point, I think my advice to the board is that you have made your findings. You're in the middle of making a motion, or actually technically a motion's been made and seconded, so really a roll call needs to be done. If the board desires to reopen the item after the motion, you can make a motion to reconsider it now and reopen it and have further discussion if you want, or hear further from the applicant. But at this point, everybody's been given their opportunity to present their evidence, make their argument as to why the board should have found positive findings, and the board made the findings that it did. So at this point, I think it's most appropriate for Diane to do a roll call since the motion is pending, and then we can discuss after that if the board would like to.
Brenda Cullinan?
Yes.
Jesse Slusser?
No.
Vlad Dumitrescu?
Yes.
Alec Hayes?
Yes.
Mike Miles?
No.
Robert Cohen?
Yes.
At this point, the item is closed. You've made your findings, a motion's been made, then the roll call's been had. At this point, if any board member would like to have a discussion about reopening that variance request for the pool, you're more than welcome to have that discussion if you want. If you'd like to try to make a motion to reopen it and see, what your board members think. Otherwise, the item at this point is concluded.
Sufficient yes, your votes yes that it's denied. Am I correct? I lost count of this.
It's denied.
Well, so
yeah.
Technically, the way the rules read is that you need, and I probably tried to pull it up on my phone, but you need 5 in order to grant a variance, I think is what the land development regulations actually say. So the motion to deny is really an administrative task at this point, because the board has made findings that not 5 board members agree the variance an element was met. I'm just a little tongue-tied right now. So that motion.
Okay, the counting of votes for approval versus denial is a little different.
I believe so under the way the rules are written, because I believe it says 5 board members have to make positive findings to grant a variance.
Interesting. Okay.
And which were the 2?
So we had
4.
Number 3, which is that the special conditions and circumstances have not resulted from the actions of the applicant, only received 4 positive votes. And item 5, which is that the reasons set forth in the variance petition justify granting of the variance, and that the variance is the minimum variance that will make possible the reasonable use of land, building, or structure, only received 3 positive votes. So not hearing any discussion by the board, it sounds like the item is concluded for the evening.
The others that you have approved it to build the house, but the desirability of the swimming pool is, but is that the only thing that would make the reasonable use of the land? I think not. I don't think yes or no on a pool makes the use of the land reasonable or unreasonable. May not be most desirable on the part of the people that want the pool, but it's not unreasonable, is my thinking on that, the way that is worded.
Right, and just for the record, so I did pull up the land development regulations. It's section 2.2.4 for Board of Adjustment, subsection C, meetings and quorum, subsection 1. Subsection 2. The concurring vote of 5 members shall be necessary to reverse a decision of the chief building official or grant a variance. So because the board did not receive 5 concurring votes to find 2 of the elements that are required to grant a variance, the variance should be and was denied.
It almost seems like just, it's going to, if a motion was made to approve and it didn't get 5 votes, or the number of votes to approve it, then it's automatically disapproved.
Well, my advice to the board would always be, if the board as a body did not establish all the findings that are required, then it's really your duty to vote to deny it.
Okay.
Because as a board, you have determined that it did not meet the 6 elements that you're required to find.
Okay.
Would you grab me a minute to speak, please, if that's okay?
This is total. This
I didn't
at this
realize
point
that I
is
wasn't able to speak before. I
the.
didn't know that I was going to be shut up.
A 60-foot lot, special situation doesn't even exist.
So, Chair, at this time, are we moving forward on the agenda, or you want to entertain
yeah, I
some
was waiting to
comment
see
from
if-
the applicant? It's up to the board to really make that decision.
We've announced that the outcome of the vote on this case is that the approval was made to grant the variance for the side setback and deny the variance for the front setback swimming pool change. All right? That concludes the cases that we have for action tonight. Are there, let's see, any other legislative items or informational items that the city or the staff needs to present to the board or discuss?
Dozens of these things are approved in this town all the time.
Comments?
So I just want to remind everyone to mark your calendar. The next regularly scheduled meeting is October 4th. And also just to remind you that we only communicate with you electronically through your city emails, so please be sure that's how you're just periodically checking. The other thing I wanted to just bring to your attention is that the next city commission meeting, the agenda should be posted next Tuesday. There are 3 ordinances that are listed for first reading. That will be, and something we discussed, I think it was a couple of meetings ago. We're trying to move forward ways to combine and streamline development review so that, one board is looking at all of the issues if possible. And also, it does expand the administrative authority for building permits, some things not having to go before a board that do now. There's been a pretty thorough presentation at Planning and Zoning Board. We can send you the links, but just so that you're keeping up, since you are charged with certain authorities under the code, it's just changing that. And some of the issues that you've seen, specifically one tonight, where there is a dedication that's resulting in a setback, that consideration would be moving to the Development Services Management Group for consideration, which is comprised of all of the directors in the city that have, a building technical expertise. So it's comprised of the city engineer, the building official, the fire chief, public works director, utilities director, and the development services director, which is me. So that some of these issues of trying to build out city infrastructure that impact private property could be maybe considered based on the different needs of the city in terms of utilities and other things happening in these right of ways, so that it would not, you can focus on the larger issues at hand. So I just wanted to make you aware of that effort moving forward. It would not be finalized until October, so we'll keep you all abreast as the changes happen. I don't think there were significant changes related to the makeup of this board or the types of items that you would hear, outside of the one I just explained.
Question, just is any information, we had to extend terms, so we understand that. Any action pending, or what's the status of that?
So again, I think Board of Adjustment wasn't innately changing as much as the reconsideration of what types of applications would go to SPRAB and Planning Board, and that's where I think where they're getting shuffled more. So the idea is first reading at the next City Commission meeting in September, if we stay on schedule, we would be hearing this adoption of that effort the first meeting in October, which would allow for seating of the permanent boards at the following meeting. That's why we asked everyone to just extend, just to make sure that we had everyone here serving while we were finalizing this issue. So thank you all, those of you who agreed to stay on. We really appreciate it.
I raised it before, and I will not be here in November.
Okay.
You're
going to put in for another board.
Drifting the world. So
you're going to put in for another board.
I won't be available for a meeting. After you asked me to want to say November, December, January, I will be out of town.
Okay. Thank you.
The first Thursday.
All right. Thank you.
Thank you very much. If not, we're adjourned. No.
Thank you very much, ladies and gentlemen.
Guys, have a good one. Copies of all these things. I don't think I need any more copies.
I'll see how it works there.
Excuse me, would I be able to speak even if it doesn't count for the record? I just want to make a note of something. So, I think people come in here thinking like I'm some kind of big developer that